Welcome to David and David on Real Estate. Join us as we explore the ins and outs of the real estate market.
Good morning and welcome to the David and David on Real Estate podcast. We are today on episode 79 and a big one coming next week, David.
Yeah, what do you got lined up next week?
I don't know. We have to
Number
choose
80.
Number 80 next week, right? We got to choose a really monumental topic for everybody.
Yeah, I was at an event, as you know, this week, and I was talking to someone who's going to come on in a couple weeks as a guest, and she was asking me, and she does a lot of these things, you know who I'm talking about. Yes. And she's like, how many of you guys done with this? And I said, like, we're almost at our 80th episode. And she goes, like, really? Like, what do you talk about for all these? So I said, we managed to find something. We get some interesting guests on. We get sometimes it's just me and you, but we always find something to talk about, and today's no different.
And the industry is ever changing, and it's always ever evolving. So there's no shortage of topics and things to discuss, and it's a lot of fun. Like it's been easy to talk about these topics just because of how involved we are in the industry and how many things your office and my office sees. But I think it's important that we keep adding value and we keep discussing these issues, and hopefully people learn from what we have to say.
Yeah, and like I said, there's always changes. There's changes in the economy. There's changes in the market. It's a moving target, and then the different levels of government decide to throw us new laws all the time and new regulations, and then that gives us other topics and things to discuss, because we're trying to stay on top of things and keep the audience informed of what these changes are and how it affects them and how it affects their deals and the market and everything. So they keep feeding us some stuff, and whether we like these changes or don't like them, they come into play, and we got to figure out what adjustments we need as real estate agents, as lawyers, as consumers. How does it, as business people, how does it affect us and our businesses? So just as business owners, we're constantly got to look at these things and say, okay, what does this mean? How is this going to affect us? Is this going to make us busier, or is it going to give us less work because of these changes? And what do we have to do internally? And how do we educate our own people about this, and our own staff and ourselves, and get on top? And then what word do we want to get out there? So there's always something to get our attention.
Always something. And then I really enjoy, the podcast that we actually talk about court cases and how the regulation from the three levels of government has been interpreted, applied, and what the end result is, and how the courts have looked at it, because, that's almost the final journey in the story, right? So how the courts have really interpreted those regulations sets precedent, and that's really the interesting part, because that's the final outcome to all the regulations and to what is actually happening in the industry. So I love when we actually look at court cases and look at court rulings, because it kind of puts everything that we talk about, David, into perspective.
Yeah, it does. And just the way our system works, like we have our legislative bodies on the federal level, the provincial level, that create laws. And, for good, for bad, sometimes for political reasons, they're creating certain laws, and it's hard to draft, like it really is. It's hard to draft laws. And the first thing that happens as soon as a law is created is everybody's looking to figure out the loopholes and see how they get around it. And I think the greatest examples of that is something like NRST. Like the second that hit the paper, like that, it was, everybody's just right on top. How do we get around it? How do we get around this? What's this? What if we do this? And what if we do that? And but most laws are like that, because it's really hard to draft something with like full clarity and to close all the potential loopholes and things like that. So, but then, like you said, it's, that's the law, but then how is that law going to be interpreted? And that's what makes it interesting, because people are trying to find a way around it, or going about their business, and all of a sudden, no, somebody decides what you did was wrong. We're not going to accept that position because that's not the correct interpretation. And that's where you get the case law, because it goes to court because you can't settle it. Now, most things don't go to court and do get settled, but we're sort of fortunate that enough really get through the court system. So a judge is actually making a ruling on it, an interpretation. And then oftentimes that gets appealed. So sometimes we wait to discuss some of these things till after it's been appealed and see what the appeal court says. Like, did they agree with the way the judge interpreted it? Because, like it's really hard. It's good. You could be the greatest judge in the world and they all get appealed at some point in time. And now you got a panel of a couple other judges that are trying to figure out if that judge interpreted the law correctly. So that's just the way the system works.
There's different levels of judges as well, right? Like when you look at the Ontario Superior Court, which deals with, and that's already the second level of court, because the Ontario Court is the first level, right? Then you have the Ontario Superior Court. Ontario Superior Court deals with all family issues, and then you have the Ontario Court of Appeal, and then after that it goes to the Ontario Superior Court, and then I think after that you can appeal to the Superior Court of Canada.
Supreme Court of Canada, yeah.
Court of Canada.
Right. And Supreme Court of Canada it's not an automatic thing. If you apply for something and they take a look at it and see if there's enough merit for them to even hear it, like does it have some element of a national interest or significant enough for them to even, to look at it. But I guess it's important for anybody, listening to this to understand a little bit of the basics. Like when you go to trial, the judge in the first trial is hearing evidence and testimony live. People are sworn under oath. They're on the stand. It's the classic thing you see in court. They're sworn in. They're, and their testimony is under oath. They're presenting the documents as exhibits so that you have this evidence being presented to a trial judge. But he's the only one that sees that. When it goes to an appellate court, there are no live witnesses taking the stand. Like they're not redoing the trial. They're only evaluating, did the judge do a proper job? Did he misinterpret something? Did he misinterpret the evidence by other principles of law? And based on the evidence that was already presented, they're taking a look to see if something was interpreted incorrectly. And so it's a different process because they're not doing a trial. They're not having live testimony and cross-examinations of people again. So it's a different process. So, part of what they're doing is examining, did the trial judge make a mistake? Is there evidence that he should have accepted or shouldn't have accepted? Did he interpret it wrong? And they take a look at it from that point of view. So, it's always interesting. And I don't spend, as a real estate lawyer, I don't spend a lot of time, looking at law and legal cases because it's just not necessary for the day-to-day thing that I do. But we get weekly notices of new cases and things like that. And a lot of them I don't pay any attention. It's got nothing to do with the areas I practice in. But every once in a while, there's some cases that, that really come out from a real estate point of view. And that's what gets your attention, gets my attention.
Yeah, and we love jumping into those and exploring them and reading them over, and they're important. They're important because they give a lot of context to the laws that are written and how they're actually interpreted and how they're going to be interpreted in the future. Because there's one of these legal principles. Is it a legal principle, maybe? But how a court rules, especially the appellants in the higher courts, the lower courts have to follow those rules and rule in similar ways in future cases. What's that called?
Yeah. Well, once a decision's made, then in a future case, they're always looking back to see if there was something already decided. There's a precedent already established by a previous case. And then there's always an argument made that we should be following the case of whatever it was called, Gorski versus Korman, because it was already decided on the point. And then somebody on one of the sides is going to say, no, although that was already decided, we can distinguish our facts from those facts because there's a difference somewhere. And they try and say, no, the case of Gorski and Korman doesn't apply to this fact situation because there's something different about it. So that's that's part of what the lawyers that are doing the trial work and the appeal work are looking at too. So you have the established cases that sort of say, like, this is certain common law cases say this is sort of the law on this point right now, because that's been established. But with any of these things, you always have to go back to the facts. Everybody's facts are usually a little bit different. It's really hard that you get the exact same fact situation as a previous case. If you do, then you might know what the answer is, because it really falls under a precedent that's already been established. There's already case law on it. But most of the time the facts are a little bit different. And it's a question of how different are they? Can you distinguish this from another one? But we still look at the cases, because it's not just, the cases often discuss previous cases and rulings and decisions. So it gives you just some of the basic principles that help guide us on our normal transactions, so we don't get to court and we don't have those disputes, because we sort of get an understanding of how our facts might fit and how that might be interpreted. So, so it's sort of interesting from that point of view.
All right, so let's jump into it. What's the first case we're going to be looking at, David?
Well, this one that I wanted to bring, because I know this is right up your alley, especially within your other hat, with everything you do with InAgent and everything. Like, you spend a lot of time on the investment side and encouraging people to invest in real estate, not just be homeowners, which is great. And homeowners generally over time, do well with their property. They don't always think of it as an investment, but it turns out most of the time it's a really damn good investment, probably the best investment they ever made, right? Even if they live in the same house for 25 years, it's going to be a great investment usually for them. But you spend a lot of time to encourage people beyond that. Like, what else are you doing? Can you have more money invest and buy another property as an investor, right? And you're encouraging agents to do that. You're encouraging consumers to do that.
Yeah, it's a big trend right now, David. I mean, the hustle trend is very big. It's probably one of the biggest trends out there, and people realize that you can make extra money and really improve your financial situation by investing in real estate. And we're seeing this huge trend evolving, and people are really excited to kind of look at real estate in a very different lens, right? But with that, there do come a lot of government regulations and rules that everybody really have to know and be aware of. And as a realtor, the rule that realtors are followed is that, hey, if you live in a property and it's your primary residence for at least 1 year, then it's not subject to capital gains tax. And there was really no true meaning around that. It was more of an unwritten rule. And the rule before January 1st, 2023 was that you can spend any amount of time as long as you're not engaging in a business activity. So they were looking at the consistency and how often you were flipping properties, not how long you lived in the actual house. But now the rules changed in January 1st in 2023, and the government came out and actually said you have to live in the house for at least 1 year. It has to be your primary residence for it to be exempt from the capital gain tax. And now I guess we're seeing some court cases go through the court system, and we're seeing how the courts are ruling on those CRA decisions.
Yeah, and that's a real important thing. Like, that's something that we all benefit from in this country, because not all countries have that your principal residence is exempt from capital gains tax. So that's really significant. So let's just, if you put dollars to it, let's say you buy a house or a property, for $500,000, you own it for 10 years and you want to sell it, and it's now $1 million. So you made a $500,000 profit. So the government says, it's always been our law here, if that's your principal residence, that's where you're living, when you sell that house, you don't have to pay a tax on that profit, on that $500,000 profit. You have an exemption from capital gains because it's your principal residence. So that's great. And you don't have that in a lot of countries. It's just not set up that way.
Yeah.
But if you bought that same property as an investment property and you rented it out and it was 500, and now you're selling it for $1 million, you have a $500,000 profit on that, and that's taxable, and you're going to lose half of that to the government.
Yeah.
Right. So there's a big difference.
Yeah, one of my agents that actually took the in-agent designation gave me a call a couple months ago, and he said, David, I have the sum of money, and what should I do? Should I buy 3 investment rental properties, or there's this amazing opportunity? I'm looking at this waterfront property in Etobicoke, and I think I can get a really great deal on it. Like, which route should I go? So I basically said to him, look, I can't make this decision for you. It's a personal investment decision of what your investment strategies are. But I said, one thing I would consider is the personal residence tax exemption. So if this property that you're planning to buy on the water is your personal residence, then when you sell it, it's going to be exempt from taxes. And I didn't hear from him for a couple of months, and then I get this invitation, come to my housewarming. And I look, and he bought this gorgeous property on the water in Etobicoke. It was listed for $3.5 million, and he got $963,000 off the asking price. He closed it for $2.5 million. And I went to the housewarming about 2 weeks ago, and I was blown away. I could not believe, what kind of a deal he picked up. And the deciding factor for him buying that property was the personal tax exemption for real estate. And he just said, look, I think this property with a renovation could be worth up to $6 to $8 million in the next couple of years as the market turns. And he's like, that was my deciding factor. I'm going to live here. I'm going to enjoy it. I'm going to renovate it. And then in the next 5 to 8 years, I might sell it and realize that personal tax exemption when I sell that property. So, I was not only very, very proud of this agent, 2 years in the business, took the in-agent designation. A lot of his success has been working with investors, and it's just a great success story. But I think it also shows the importance of understanding the law and knowing what the regulations are to be able to make the best investment decisions for, your clients or yourself.
Yeah, no, that's a great story and a great example. Now, if he was living somewhere else happily in another home, he could have still bought this property as an investment property. It would probably set from the sounds of it, if he got it at that price, he could still do the same thing. He could rent it out for a while and then renovate it and eventually sell it. He'll still do well, but he won't do nearly as well because he loses that personal capital gains exemption on it. So it still could have been a good decision for him to do it if he was going the other route, but there's a significant difference in the cost. So the fact that he was in a position in life that he could actually move in there, establishes a principal residence, and then do it is like a real win-win. And I love the fact that, that he took the step to even have a housewarming party. Because as we see from the cases on this, like when you're trying to establish something as your principal residence, the government looks at all those type of factors to determine whether you really moved in there. Was it really your principal residence? So in fact, you had a party there, you change all your ID to show that's your residence, all your mail goes there, you make sure you get cable there and Wi-Fi, and you're using utilities there. And you'd have to be able to establish that you don't have a principal residence somewhere else, right? So all those factors are important when we talk about this anti-flipping thing that came into effect January 1st.
Yeah, and I'll share a personal story. And I mean, this happened to me a really long time ago, where I had a really beautiful penthouse listed for sale in Mississauga. And I bought a property in Oakville, and I couldn't sell the penthouse. Like, this is a really large, expensive apartment, and I couldn't sell it. And my intention was to move to Oakville, and I did. For about 2 weeks. I moved into the house, and what happened was I had to list both properties on the market because it came to a situation where I couldn't carry both at the same time. This is a really long time ago. Really regret selling either property, by the way, but this is just the situation I was in. And then what happened was I actually got an offer on the house first before I received an offer on the penthouse. And I was in a situation where I accepted that offer on the house, and I moved back into the penthouse. And the government called me and I explained the situation. I said to them, look, I had every intention. I changed my address. I moved in there for about 3 weeks. And, then I showed them the 2 MLS listings and I said, look, like, unfortunately, I got an offer on this one first. Not my intention to flip it. All my intention was to move in there. In fact, I changed all my mailing address and I did live there for a very short period of time. And they let me claim it as my primary residence, and I didn't have to pay the capital gain tax, which I was shocked to see that. But it's, again, it wasn't the duration, it was the intent and the actual usage of the property that had the underlying conditions attached to it.
Yeah, and that's a great example, and that's why I always, when I discuss these type of things, it's the facts are so important. Okay, and sometimes people just don't appreciate that, but the government is looking at, when they get involved in these things, they want to see all the facts. They want to see what's real and what's your lifestyle. And they want to hear your story. And sometimes they're going to accept it, sometimes they're not going to accept it, but that decision is basically comes down to what were the actual facts and circumstances, what was the intention. And a lot of times people will get that one freebie like you sort of got from the government, because you weren't in the business, you weren't doing this all the time. If they see that you have a history of doing it, or you've done this more than one time, all of a sudden it raises an eyebrow and they go, well, nice story, David, but I don't buy it because last year you did the same thing.
Right.
So everybody will sort of get a one-off on these things. And that's happened for a lot of people. That I have a lot of clients that have been in the business of, buying a property, renovating it, and with the intention to flip it, but they will move in themselves for a period of time. And a lot of this was even before this, was before this 12-month thing, when there was nothing in law that said you had to live there for a certain period of time, but you still had to establish that it was your principal residence, and then you sell it. And a lot of times the government would allow people to do it, and they allow them to do the first one. They might allow them to do it the second one, because they can really establish this is their principal residence. They're not living anywhere else, right? So they're really moving in, but it might only be for 3 months, and then it goes on the market and they sell it, and then they're out and they do the same and they move into the next one. But at some point they're going to say, well, no, you've done this 2 or 3 or 4 times. This is now becoming your business
activity.
It's right. The nature of a trade, and we're now going to consider this business income. So you can't do that anymore. Yeah. And this is before this, obviously, this new anti-flipping law, which clearly says we have a 12-month period where we want you to be living there in order to do that. So that would change, anybody that wanted to do that, buy a property, live in it and renovate it and then flip. So you can still do it, but you got to be there for at least 12 months now. So it slows you down if in that process.
Yeah. And I mean, obviously in my situation, I just shared with everybody, under the new laws, I'd have to pay taxes on the gains that I made, and they weren't significant, but there were gains. So that just clarifies a lot of these situations and takes the ambiguity out of the law, right? Yeah. And it's something that we talked at the beginning of this podcast is how these regulations go through the court systems and how they get interpreted. So the government always does their best to make sure that when they write these laws, they put in enough information in there and they write them in a way that it leaves the ambiguity out of the table. And now that they changed that on the 1st of January 2023, now there is no ambiguity. You got to live there for at least 12 months, otherwise it's taxable as business income, and you won't get the personal exemption. Yeah, so let's jump into this.
Wait, now they do leave some, that's the basic rule. Like you got to be there for 12 months, but then they also created part of the law that there are some exceptions. So your fact situation might fit one of the exceptions. Like if there's a death exception, a disability exception, if you become separated, or if you're working remotely or not working remotely, you're being relocated for business purposes, like you intended to live here. But here's evidence that the company I'm working for requires me to move. So I was planning to live here, but I can't stay for 12 months because I'm 6 months in and my company requires me to relocate somewhere. So they do have some exceptions too. And that's why I say it always comes back to the facts, right? But so we look at each case on its own. And in this particular case, what was a homeowner that was going through some sort of messy divorce separation situation in Toronto, and she got reassessed for I think 3 or 4 different taxation years, and she owned 4 properties at some point during that period. But there was this one property that she had sort of been in a couple, lived there a little bit and didn't live there because when things weren't going good with her husband, and she was arguing that this was her principal residence, and they were, so that's one of the things that they had examined. Did it qualify did she establish enough that this was her principal residence? And they basically said that she never really changed everything to make it her principal residence. She didn't do enough to change her address and mailing address and everything there. So they took the position that it was really, it was flipped. So the first thing to look at, was this an adventure in trade? Like, was this just a business opportunity, or was she really trying to live there? So, and they said, she's not like a normal flipper. She's not David Gorski, who's an investor trying to, to own as many properties as she could. So, they sort of understood, she had some difficult facts. She wasn't a sophisticated real estate agent like you are that maybe understands this, but still, she didn't establish enough that this was the place that she was living, because she was sort of in and out and a little bit transient there.
Right. And I guess in a regular case, you change your driver license address, you would change your utility bills, you would change your CRA mailing address. That's a big one, right? You would register a car to that address. There would be evidence and clear evidence that, at some point that was your primary residence. And you could have testimonies from neighbors, you could have pictures of different parties that you did at the house, right? But in the absence of that, it's really hard to prove that, you did intend for this to be a primary residence, right? So I think, when you shared the details and I read through it, it was very vague in terms of what the evidence was that this was a primary residence. And I think when a court sees that, hey, this person hasn't really changed their addresses or all their addresses. I think she had some utility bills in her name, but I don't think she had a driver license or some of the other documentation that she should, if it was her primary address. So I think it was vague at best. And I don't think there was really any concrete evidence that this was a primary residence. And, the court, David, help me out here. How did they rule in this case?
Well, the first thing is that they're looking at, was this an adventure in the nature of trade, or, could it be treated as a capital property that could fit this exemption? They said, well, she's not really someone trading, so we could consider this a capital property. Okay, so so she sort of passed that first test. But then the second test, if it is a capital property that could qualify for the exemption, was this really her principal residence? And that's where she didn't really meet the test, because there wasn't enough to establish that this was her primary and only principal residence. There was evidence that she was living elsewhere, and she didn't do enough to establish this as her principal residence. So even though they said, okay, you're not a flipper in the classic sense, you pass that test, but this really wasn't your principal residence, so we're not going to give you that one. And then the case went on to look at a couple other points, because the government has a certain period of time when they can reassess you and look at it, and this was actually beyond that time frame. So they can only look at it if they found there was some misrepresentation. They can only open it up and reassess this if they thought that there may have been some misrepresentation by the taxpayer in previous filings or submissions, or anything, to allow them to reassess this, even though the normal period had passed. So, they decided they were going to do that. There was enough going on here, and they allowed to do it, even though they didn't think that she was doing it necessarily deliberately or something. But that's why it's always interesting to look at some of these cases, because like there's so many different issues that are sort of dealt with in the context of a particular case. And then it's like me and you were just looking, what's our takeaways from it? It's like, you know, can you flip a property? Yeah, you could flip a property. No one's saying you can't do that. You're paying a different rate of tax if you're doing it. So how can you avoid doing that? So number one, you got to live there for at least 12 months. Number two, you got to really establish it as your principal residence and have, to be able to show that.
Right. And that was very disappointing when I read the case that they opened and they, went above that limitation period. Because to me, she wasn't a flipper. Yes, she didn't claim she claimed the exemption and she wasn't entitled to the exemption, but there really wasn't any malicious intent here. She didn't have a history of doing this. So, when I read this case, I really didn't understand why the courts went past that limitation period. It really was unclear to me. And that was disappointing as an investor, knowing that, if you do, claim a property as your personal tax exemption, that the government has that right to go past that limitation period. And, we all hold our breath for, that period and then say, okay,
Right.
we is done. We don't have to worry about it. We can destroy those records. We can,
Right.
Shred that tax evidence. And then the court says, well, we want to look at it again. And, as an investor, as a business owner, as an entrepreneur, as somebody who loves the law and reads the law and really wants to stay on top of the law, David, I didn't quite understand that.
Yeah, and that's a hard thing for me to understand too, because generally, like it's a 7-year period they can go back and reassess you, right? So in this particular case, it was her 2011 tax return that they were looking at, and this decision came out in late 2022, right? Till this got through the system. So 2011, you think by 2018 you're pretty safe to get rid of your records. You're not going to be assessed, and that's what most people do. Maybe you hang on to it for a couple more years. It's 7 years. Maybe you hang on for 10 years. At some point, you're going to destroy it. And that's part of what we don't know the underlying facts, but that may have been part of her problem here. Maybe when this did come up, she didn't have enough evidence left. Maybe she got rid of some stuff and she couldn't establish that there wasn't this misrepresentation or anything enough so the government, was able to open this up, 11, 12 years later and reassess it. So I agree with you. Like that was sort of a disappointing thing. And I don't think we have enough of the facts, but just by virtue of all that time going by, it's quite possible that she didn't have all the records available anymore. And the way we stored records in 2011 is very different from how we do things now. Like, now it's, obviously it's easier to store things because you scan it. If it was paper, you put it on your computer, you can keep it that way. And you don't feel like you got to get rid of it as fast because it's not cluttering up your basement any in boxes and stuff. Right. So, going forward, maybe we'll all be keeping our records a little bit longer. But I agree, that was sort of a disappointing part of that because man, that's a lot of time. Like to go back, it would have been better. Oh, yeah, this happened 2011. We're way past our time to examine this. Even if we think she may have done something improperly, she's off the hook just by the passage of time.
David, if I may be so bold, I think this is one of those perfect cases for the appellate courts, and because they don't rule on the evidence per se, they rule on how the law was interpreted. And I think this would be a perfect case to appeal and say, hey, you know what, we were, yes, we talked about this and it was discussed, but I think the trial judge erred in their judgment to reopen. And I think the statute of limitations should have applied here. So I would appeal that court decision if I was the defendant and see what the appellate court would say about the statute of limitations, because that is one of those thresholds that is really hard and high to meet. I mean, the court does have the power in their to go ahead and put that threshold aside,
Yeah.
but there has to be enough evidence or some sort of a negligent situation or history of repeat behavior on the defendant's part to justify that. And in this case, it was so cut and dry. Like, she hasn't flipped before, she just owns a number of properties. She was going through a personal situation, which you mentioned was one of the exceptions to that 12-month period, right? So,
Well,
I mean,
that's under the current law, but that's not the law that necessarily applied in 2011.
right.
Right. So there's a difference there, but still, like, you're right, though, they went after her, for something that was really old. You're only supposed to do that if there's some clear evidence that she didn't report it back in 2011 for, from some negligent point of view, or because she should have.
Yeah.
But I don't think there's anything clear that I saw there that would have required her back in 2011. There wasn't this anti-flipping law back then, right? So she didn't. This wasn't a non-compliance with the current new law. This was a non-compliance that goes way back before it was even, this 12-month rule. But anyways, it's an
Think
interesting
about the precedent that it sets, right?
Yeah.
Like, the precedents for everybody, like, us, me. Now I have to go and dust my tax returns from earlier and make sure that I keep them, right? I mean, it's the precedent from this is
Right.
really big. So
Yeah.
very interesting case. And I love the fact that we brought it up when we were discussing it. And then it goes a little further, because the CRA tried to impose a penalty on her for what was the penalty for?
Well, they're saying if she was grossly negligent in not reporting this in 2011, then she could be subject to a penalty for that as well. And they at least they let her off the hook on that one. Whether the facts were supported or not, I think they just decided, okay, enough's enough. We're going to tax her on that. So let's not impose a negligent as well, because I don't know if they had enough evidence to establish that she clearly did this on purpose, and she was really trying. So they just said, okay, this may not have been a deliberate act, because if they find it was a deliberate act to do this, like, if they think that you knowingly did this to avoid paying tax, they could impose a penalty on you in addition to the taxes that are owed. And these are taxes that are owed going back to 2011. So it's the taxes plus the penalty and the interest on the taxes. But they let her off on the penalty part of it, at least, because maybe they had some sympathy, or the judge had some sympathy for her. So it could have been worse. It could have been worse.
It wasn't pretty, but the CRA went for the jugular, and finally the court said, okay, you know what, we've taxed her enough.
Yeah.
What's the next case we're going to discuss, David?
Well, the next one, I did as you're aware, I did a webinar for your office yesterday. We were talking about defect disclosures and what's the obligation of people to disclose if there is a defect, different types of defects, and had all that discussion. And something that comes out of that conversation is what did the seller know, and what did the seller tell you in your agreement of purchase and sale? Did the seller make any representations or warranties? Did you have a clause right in your agreement of purchase and sale that they warranted or represented that the chattels were all in good working condition, or that there'd been no leaks ever on the property, or there's been no fire on the property, or there's been no use of the property as a grow op, or things like that, like those classic type of representations and warranties. And in the absence of that, of any representation warranties, what's the basic law on it? And I made the point in the webinar that in everybody's standard form agreement of purchase and sale, there's a clause in there that we refer to as the entire agreement clause that basically says there are no representations or warranties made by the seller, no other agreement or condition that affects this agreement, except for what's actually written in this agreement of purchase and sale. Okay, so that's the argument that a seller uses and points to all the time when you close a transaction, then something comes up after closing. They find that there was a defect, or there's a leak, or there was damage, or there's mold, or there's the appliances aren't working, things like that. You always have to go back to the contract. So if the seller didn't make specific representations and warranties in the body of the agreement purchase and sale, the seller can always point to that entire agreement clause to get off the hook and say, hey, I didn't make any representative warranties. There's a clause right in here that says if it's not here in writing, I don't have to be held responsible for it. So it's a really important clause. And when we lose sight sometimes of these pre-printed clauses that are right in the agreement, we don't put our minds to it because we're busy just looking at all the blanks we filled in and the clauses that we add. But it's a really important point. So there was a recent case that sort of dealt with this issue about the entire agreement clause, and it's not even a residential case. It wasn't a residential transaction that was involved, and the issue that came up on this transaction is if there is an entire agreement clause in it, because this was a commercial transaction, but it has the same clause in it, and then there's fraudulent misrepresentation by the seller, does that clause get the seller off the hook? Because they didn't make a specific warranty or representation in the agreement purchase and sale. So you have the entire agreement clause, so that would normally cover the seller. But if there was fraudulent misrepresentation made by the seller, it's somewhere in the facts, can the seller still use that entire agreement clause as a defense? So it's got nothing to do with residential transaction, commercial fact situation, but that's the basic principle that it was examining.
I'm just reading it over right now.
Oh, okay. Well, I'll just go through some of the basic facts. And this was an Ontario Court of Appeal, so it went to trial, and now this is a Court of Appeal decision. So again, they're examining what the judge ruled, but the basic transaction was a purchase of a laundry business. So it's a commercial transaction, not a big $290,000 purchase price, $100,000 deposit, $190,000 was supposed to be paid on closing by way of a vendor take back mortgage for a 4-year term. So the seller is taking back a mortgage for the difference, $190,000. But there was then the buyer doesn't defaults. The buyer stops paying on it after closing because there's problems in the property, and the buyer was saying there was fraudulent misrepresentation by the seller, that induced the buyer to buy this business because it wasn't as the seller made some fraudulent misrepresentations about the income of the property and how the business worked, et cetera, et cetera. So there was a summary judgment. So it goes to trial, or there's a court application by the seller, and they don't even go to a full trial. They go to a summary judgment, and the judge says, yeah, we think we're prepared to make a ruling, because a judge at that point can say, I haven't heard enough, so I want to have a full trial, or there's enough evidence just on the face of it here that I can already make a decision, and we don't need a full trial on it. So, then the Court of Appeal looks at it and they go, no, let's set aside the judgment, and we should send this back because there really should be a full trial on the issues. We think the judge made a mistake on this in their interpretation of that entire agreement clause.
Right. But then it went through trial one more time and ended up back at the Appellate Court of Ontario again. So this went back and forth to the different court systems, which was really interesting.
Yeah. Well, the basic principles, and that's what we're sort of looking at here, with what they're looking at. Like, the judge took the position initially that the buyer is supposed to do their own due diligence, and the buyer had opportunities to do their due diligence, to do an independent analysis from a legal point of view, with legal documents, accounting point of view, look at everything before the deal was closed. And once they close the deal, then, that's, if they didn't do a good job, that's their responsibility. They got to take ownership for that. So, unless, what turns on these factory situations, unless the seller did something actively to prevent the buyer from doing that due diligence and hid certain things or misrepresented certain things. And that's where, the issue comes up, because the entire agreement clause is a great defense to a seller. And it would be, so in the normal case, if there was an opportunity for the buyer to do their due diligence and everything was presented to them, and there's no representations or warranties directly in the agreement, because let's assume there were none. It was like, no, I'm selling this to you. You got a conditional period. You can do your due diligence. During due diligence period, I'm going to provide you with our financial statements. I'm going to show you our books and records. You can talk to the employees. You can look at everything and see how the business operates. And we're disclosing everything to you. But once you waive the condition, then we're closing, because I'm not making a representation and warranty in the agreement that everything is true and accurate, or I get everything. I'm just giving you everything. You satisfy yourself. You're satisfied, waive the condition. Now we close. Okay. So if you did a bad job in doing your due diligence and you close, and after closing, you discover you made a bad deal, and you can't go back at the seller to say, hey, you owe me some money, or we got to redo this, or I want to get out of the deal, or I want to. You can't. And the seller can't justifiably point to that entire agreement clause. No, I didn't, because that agreement clause, entire agreement says I didn't make any representations or warranties unless it was in the contract. I didn't do anything. I gave you everything for you to examine it on your own. Now, if the seller misrepresents stuff in that disclosure, they don't give you everything accurately. That's what this case is about, because the seller, if there is a misrepresentation by the seller and they didn't disclose everything properly, then the seller can't use that entire agreement clause as a defense.
Right.
Okay. Yeah. Because the misrepresentation itself will defeat that entire agreement clause.
Yeah. And it makes sense. So, I think the lesson here is that if you go through a due diligence period in your agreement and there's things that you are concerned with, then do an amendment and put your concerns in writing and ask for further warranties or representations or clarifications that now becomes part of that initial agreement, and do it in writing, right? That way it forms part of the agreement. It's together, it's clear, it's written, and now you can rely on those representations that go with the agreement. So, it's a great, way to kind of make sure that you clarify and you put in writing whatever you think you're asking for, you're getting from that transaction and from the seller if you're representing the buyer. And it makes sense. Our OREA forms are, in my opinion, extremely well written, and they keep improving them over time. So as case laws goes through the court system, and as the court rulings evolve, and as our industry evolves, we have a great team at OREA that keep developing and keep working on these forms and keep modifying that printed language, because they want those forms to be standard, and they want to cover the buyer and the seller in all circumstances that move forward and facilitate a transaction to completion. So make sure that you're using accurate and up-to-date OREA forms. That's really important. It's actually a REBA code of ethics rule. You have to use up-to-date forms, and this is one of those reasons. The entire agreement clause, if we look back at the first OREA form, it probably wasn't in there, but over time, these warranties and clauses and pre-printed versions of the agreements have evolved to make sure that they protect all the parties and facilitate the transaction moving forward.
Yeah, you're 100% right. So now we know that clause is in there, right? And we know that creates a defense for a seller. and it puts an onus on a buyer. It's the buyer beware, buyer, the caveat emptor principle, buyer beware, right? Buyer, do your due diligence. Okay. So you've got that obligation. So if you're on the buyer side of a transaction and you want more than that, then what this case is telling you, it's incumbent upon you as a buyer or the buyer's agent or the buyer's lawyer to get clauses in there where the seller is providing representations and warranties. So whether it's a commercial transaction like this is sort of an easier one to look at, because we need certain disclosure. We need financial statements, we need their business records, we need show how the income came in, show us what the expenses are. It's a commercial income producing business, right? So we want a list in the agreement of purchase sale that the seller is going to provide A, B, C, D, and E by way of disclosure within a certain time frame, so we can examine all that. But you've got to be careful how you draft that, because not only do you want the obligation of the seller to produce those documents, but it's better for you to put a representation and warranty that that's all there is. And the seller is warranting and representing that they are disclosing everything to you and there's nothing else. Because now, if they didn't, and there's some misrepresentation, that entire agreement clause can't be used by a seller to defeat your argument that your seller didn't give you everything or misrepresented everything. So it's telling us to try and get those specific warranties and representations in the agreements of purchase and sale. And the same thing applies on a residential transaction. Okay, because if you should get a clause in there, the seller represents and warrants that all the chattels and fixtures are in good working condition. Because if you don't have that in there, then, and something goes wrong after closing and it wasn't in good working condition closing, you come back and say, hey, the washer wasn't working after closing. Well, seller says, oh, paragraph 26, entire agreement clause, I didn't make a representation of warranty that it was working. Like, it's that simple.
I have a quick story to share. We're running short on time, but very quick story to share. So a couple of years ago, there was a house listed for sale, and we were going through a very busy time in our market. Everything was selling, multiple offers. We had an agent work with a buyer couple, lost like 15 offers, and this is in the $2 million price range. So they kept putting offers, and they were going $400,000 over asking. They kept getting beat out, and the 14th offer they put in, I think they lost by like 20,000. So this couple is very frustrated. They want to live in a very specific neighborhood, very high price range, but just everything selling, multiple offers. Finally, a house gets listed at 11 a.m. It's owned by a real estate agent who specializes in working in that particular area. The agent books an appointment, takes the couple through, and the realtor is home because she's just tidying up and just getting ready for the appointment. And the couple turns and says, hey, how big is this bungalow? And the realtor, the owner of the house, turns and says, well, as a matter of fact, we looked on doing a second story addition, and we know for a fact that, the base is 2,600 square feet, because with the second story, we're going to be at 5,200. And she goes into this whole story, right? So the couple's like, okay, thank you. Beautiful house. Well, our realtor, who was right there standing and overheard the whole conversation, is going to be in touch with you. They get into the car. The realtor's phone pings, and already another offer registered like 4 hours after the house is listed on the market. So they rush to the office, prepare an unconditional offer. They love the house, submit the offer. I think by the time the offer presentation happened in the evening, they were competing with 4 other offers. Realtor even had to reduce their commission a little bit to make this work, but finally they were successful in buying this beautiful, beautiful lot in South Mississauga. They go to their buyer revisit and bring their mother-in-law with them to see the house. The mother walks into the house, looks around, and says, there is no way this house is $2,600 square feet. Mr. Realtor, can you pull the floor plan and see what the exact square footage is? The bungalow is 2,040 square feet. So 540 square feet smaller than the representation made by the seller, who is also the listing agent and specializes in working that neighborhood. So now This is just going through the court system. We haven't had a ruling on this, but very interesting to hear your perspective, David, on what would happen here.
Yeah, that's an interesting fact situation too. Generally the rule is you buy what you see. So if they intended to buy, if they only were offering the price that they offered because it was 2,600 feet, then there would have been something in the agreement usually saying, I'm prepared to pay X dollars per square foot of the house. But on residential transactions, we know that's not generally the way agreements are drafted. So you're really buying what you see. The fact here that it's about 20% off is a lot. Like if it's 2% off, 3%, 5% or something, it's, then that's, like how can you tell if it was, 2,550 feet or 2,600 feet? Like it's right. You're never going to tell, but generally on residential, the law is you're buying what you're seeing. And if you really intended to buy on a per square foot basis, then you would have put that in your agreement. That I'm prepared to pay X dollars per square foot, which is the way people typically buy vacant land. Okay, vacant land is usually bought based on the acreage. They're paying so much per acre, and sometimes there's an adjustment clause because if it's remeasured, by a surveyor and it turns out it's less, there'll be an adjustment based on the actual acreage because that's significant. But even in new construction, where you get plans and they say, okay, here are this condos. It's 800 square feet. You're still not buying it necessarily on a per square foot basis unless you put something specifically in the agreement that if it's 800 feet, I'm prepared to pay so much, $300 a foot. If it turns out it's only 790 feet, I'm entitled to a discount. If it turns out it's 810 feet, I got to pay for that additional 10 feet, but it's not usually drafted that way. So it'll be interesting to see how this comes out. So I think that's their uphill battle. From the buyer's point of view, the fact that it was off by 20% might come into play. The fact that there might be a misrepresentation as opposed to, well, it wasn't in writing. I didn't misrepresent in writing. I just said, I think it's around that. That's what we thought it was based on, maybe we had erroneous information, but we didn't intend to sell it to you on the basis that it was 2,700 feet. Look, we had other offers by other buyers in the same price range. Everybody was buying what they see. Right. And that's the basic principle that's going to be hard for them to overcome, I think. It'd be interesting to see what happens. Because basically on residential, you're buying what you see. Same thing with, you see the front yard, you see the backyard, you see how wide the property is. You think it's usually the standard form agreement purchase and sale says the property might be 25 feet by 100 feet, more or less.
Yes, it does.
It gives you that leeway. But anybody who's buying that property, they stood there and they looked at it and they said, okay, well, I'm going to buy this if it's 25 feet, but if it's 24 feet, I wouldn't buy it or I wouldn't pay that price. No, you're buying what you saw, you made an offer and you're buying it. So usually the courts say you're stuck with it.
Yeah, and there was a little bit of context given around the square footage because the owner, who's also a realtor, said, hey, we wanted to do a renovation and this is how we know the square footage is what it is, and right. Them being a subject area expert and
right.
And a location expert, I think there could be an argument that statement could be more heavily relied upon being
right.
made in that context.
Right.
It's going to be interesting to see, and I think the lesson here is that if that square footage was really important, had that realtor just put in a little paragraph in Schedule A saying, hey, this house is being bought under the premise that it's 2,600 square feet. And the seller warrants and represents that she had drawings made by an architectural firm with a second story addition, and knowing that that's the square footage, that would change the game drastically. Right. And this is where, that entire agreement clause comes into effect. Yes, it was discussed. Yes, it was given. Yes, there was witnesses. Yes, there was context. But again, it's going to be really interesting to see if that entire agreement clause will be a defense in this particular situation.
Yeah, that would be, because that's bang on what I'm here, because that for sure is going to be one of the defenses raised by the seller. It's not in the agreement. I didn't give you a specific rep and warranty. It's not in the agreement. So yes, that should be a defense. But now there's another argument based on the case we just looked at. But was there misrepresentation by the seller that will defeat the entire agreement clause? And that's where the facts are so important. All that evidence of all those discussions and everything. And it's, was there misrepresentation? And is it clear that the buyer relied on it? And then they're going to also say, yeah, but look, there was 5 other offers all in the same price range. And we didn't, and there's no evidence that we were doing the same type of representation or misrepresentation to all the other people. That's, that's a fair market price, and it's not being sold based on square footage. So it'd be interesting to see what happens, but that's where these principles all come into play. And that's, like I keep saying, the particular facts matter. So if you're the agent on these things, you keep your notes, you keep your text messages and your emails, because you never know, all that stuff could come back into play.
And now we know it can come back into play over the 7-year marks. It's even more important.
Don't throw anything out.
No, but again, it goes to the whole idea that you need to be a professional, right? You need to understand these rules and regulations. And not only do you need to understand the rules and regulations, but you also need to understand how the courts are applying them in real life situations. So David, that's why I am so thankful that, we're able to have these conversations. We're able to share these conversations with the industry, because I think they're monumentally important, right? Regulations are there, great, but how are they interpreted? How are they applied to real life scenarios? How do you understand all the principles that my office trains you on and teaches you on, that we discuss all the time? How do they actually apply in real life cases? And I think that's where the magic happens. That's when you're starting to understand, like, what does it really look like in real life?
Right. And it's our responsibility as real estate agents, as real estate lawyers, like, to protect our clients. So we have to, if you're sitting there negotiating a deal, you've got to try and get reps and warranties in there. And if the seller's refusing to put them in, that's a red flag. You have to just, why? Is it simply because there's 10 other offers and they just want a clean offer and they don't have to right now? So yeah, we're not in that market anymore. That may have been a valid excuse 6, 8, 10 months ago, but not in today's market. Like today's market, there's room to negotiate conditions. There's room to negotiate reps and warranties. And if a seller is refusing to give you one or the other, like if they're saying, no, I don't want to give you reps and warranties, but I'll give you some time to satisfy yourself. You got 3 days, 5 days, get an inspector in, do whatever you want, do all your due diligence. But certain things you can't find by way of an inspection, right? You don't go in there, and even with appliances, you don't go in there and do a load of laundry right through the full cycle and then throw it in the dryer and see how long it takes to dry the clothes. And you don't run the dishwasher with a full load of plates and dirty stuff in it. Like, there are limitations. So you want a rep and warranty from the seller that it's in good working condition, or it's 20, the appliances are 20 years old. I don't want to say it's in good working condition. I'm going to tell you it's in working condition, because it does clean our plates. Doesn't do a great job. It's a 20-year-old dishwasher, right? But it works. Our laundry gets done. Doesn't get done beautifully or energy efficiently because it's an old appliance, right? So as an agent, try and get those clauses in, because you're exposing your client if you can't. And if the seller's refusing to give that, that should be a red flag. Like, why?
Absolutely. David, I love these sessions. Thank you. Thoroughly enjoyed today's podcast. Really enjoyed the conversation. Really enjoyed to see, how everything kind of goes through the whole process and what the end result is. And I think there's a lot of really valuable takeaways for our profession and for the realtors listening. So thank you guys for joining us. Thank you for making it to the end of the podcast. And as always, David Korman and I are here. If you have any questions, send us emails. Like we've been getting so many great responses from everybody. So, thank you guys for tuning in, and we'll see you guys next time.
Okay. Always a pleasure, David. Have a great week.
As well. Thanks so much. Bye-bye, everybody.